Alex here with a legal nuts and bolts video on default. This video is going to cover what a default is and how to go about getting one. In civil lawsuits anyway, when you file a lawsuit against your opponent and you have them served, they have a certain amount of time to respond to you. If they do not respond to you on time, in Nevada it's 20 days. It may differ depending on who you're suing. I think if you sue the government, it may be 40 or something like, or even maybe 60. Anyway, I don't want to get into that right now. If you file your complaint or your petition and your opponent does not respond within the time limit, you have a right to default them. And basically what that is you asking the court to just rule in your favor by virtue of their non-participation in the process. In other words, they can't frustrate your right to a legal remedy by just not participating. That's not allowed. And so the incentive that the courts have in place to somebody who doesn't respond or doesn't file an answer is to punish them by ruling against them without even talking to them, without even getting their input, without them even participating. Due process gives them an opportunity to participate, but it can't be abused to the extent that they could just not participate to frustrate your rights. So anyway, how do you get a default? In Nevada, you actually ask the clerk for a default. Usually, if you're, well, attorneys pretty much always will just prepare the default, and it'll look like the default. It's like a form that the clerks sign. It'll have a spot on the bottom for the clerk's signature and their stamp and all that, and they'll just basically send it up to the court blank, and the clerk will take it. The clerk will look at the certificate of service, will count the number of days, and if the clerk sees that the time has lapsed, the clerk will sign it and stamp it. Once that default is signed, stamped, and filed in your case, you can then turn around and ask the judge for a default judgment or a default decree. The judge, one of the things that the judge is going to do is take a look and see if the clerk has filed a default. It's curious here that the process involves two people. It involves two entities, the clerk of the court and the judge, and they do this separately. Anyway, the judge will review the motion, or sometimes it's called an application because it doesn't. There's no response by your opponent because your opponent hasn't appeared in the action. They're not answering, they're not responding, they haven't made a formal appearance. So sometimes people will call a motion that is just one-sided, that has nobody else is required to respond to it. Sometimes they'll call it an application. But either way, it should work. They'll read the motion, read your points and authorities, which are typically something like such and such was served on this day, their response was due by this day, they didn't respond on time, the clerk entered the default on this day, please grant me this amount of money, or whatever kind of relief you're requesting. And that's pretty much that. The courts will usually just grant it without even setting a hearing. So you'll just get like a judgment in the mail, and you can start going right into execution and try to seize assets and all that. If it's like a custody or a divorce thing, your custody order will, I don't actually think they grant those by default. You may still have to appear, and the judge may have questions for you. Divorces with no kids, I think they do grant they'll probably send that to you in the mail, and that'll be that, no hearing or anything. Anyway, that's usually what happens, but not always. If the judge wants to, he can or she can, they can schedule something known as a prove up hearing, prove up. And if they do, you will be required to appear, and you won't have to show that you are right. The court is required to rule in your favor in the sense of whether or not you are entitled to relief. But they do have the power to make you prove the damages. So the judge can sort of, usually my understanding is that they'll usually do this when somebody's asking for like a ridiculous amount of money. And so the judge can order a prove up, make you come into court and prove that you've been damaged that amount. And if you prove it, you should get the amount that you requested. If not, you still win your case, but you won't get as much money as you asked for. I don't know if there's really much else to mention. Oh, some states and some local courts will require you to send a notice of intent to default your opponent before you do it. And some judges or some attorneys will just do that just to be nice. I don't know if it's just to be nice. Maybe it's more so to show that they went above and beyond in case their opponent tries to come back later and set aside the default. They'll be able to show, look, they were served with the complaint and they were served with the notice of intent to default. So I don't know. It's probably not to just be nice. It's probably to sort of cover their butt. I think with that, I'm going to go ahead and end this video. I did mention, I kind of glazed over it. If a default judgment is entered against you and you have a problem with it, like for example, you weren't served and you've been blindsided by the judgment, I just recently mentioned setting aside the default. I actually have a video on that. So if you want to know how to set aside a default judgment, make sure you go and watch that video. With that, I will go ahead and see you guys. Thought of one more thing. Writ petitions. I just happen to know this. Writ petitions cannot be granted by default. I actually got published by the Supreme Court on an original writ petition that I filed, and that was one of the things that I ended up looking up. I ended up filing a writ petition in the district court also, and I personally encountered this problem because my ex did not respond to the writ petition that I filed. And I went and did some research and I found a statute that says you cannot win a writ petition by default. It was annoying. The judge set a hearing and I had to go in there and explain why I was entitled to writ relief. And my ex wasn't there, of course. She didn't file a responsive pleading. She didn't appear at the hearing or anything. So unfortunately, just to let people know, you can't win a writ petition by default. You will end up having to go in. Actually, the judge may or may not rule on the merits just based on your papers. But the judge won't be able to say you're right just because your opponent didn't file a response. The judge will actually have to read through it and see if you've made some kind of cognizable legal request for relief that makes sense and is legal and all that. And then if so, they can grant it just through the mail. But my judge in my particular case actually set a hearing and wanted to talk to me before he granted it. And he did grant it. So anyway, with that, I'll go ahead and end this video for real this time. I'll see you guys next time.